Welcome everyone to the Information Ecology lecture series. Thanks as always to Jennifer Jenkins, who's the architect of the series and brings us all together and arranges things with our speakers, but also gives us the beautiful descriptions of the events and sets everything up. Our speaker today is Professor Justin Hughes from Cardozo Law School. And for people inside the Intellectual Property Academy, Justin has a special role, I think, not just because he's so sartorially elegant, but because he puts together a set of attributes or qualities which are rarely, if ever, combined. There are people in intellectual property scholarship who are widely regarded as great theorists who understand the philosophy behind intellectual property. There are people who are seen as those who understand the domestic policy-making process, those who understand the international policy-making process, those who work specifically in copyright, those whose work also extends to areas such as trademark, geographical indications, and perhaps even to other areas, and those who've worked in government and are specialists, understand the policy-making process from the inside, and those who are known largely because of their incredible scholarly production. What's fascinating about Professor Hughes is he puts all of these things together. His article, The Philosophy of Intellectual Property, is an absolutely fundamental, seminal work which provides a really interesting, I strongly commend it to all of you, a really interesting perspective on the justifications for intellectual property law from two sides that are not normally used, the Lockean side based on labor and the Hegelian side based on personality. His other work is extremely wide-ranging, to put it mildly. He's and it all has great titles, which I won't attempt to reproduce here. He has a fascinating article on the idea that fair use claims should become more aggressively considered by the courts the older the work is. So an older work, you should be entitled to greater latitude for fair use. He's written on transgenic species in a fascinating comment called "Goat Boy Roams the Halls." He was involved in the Napster litigation and has a wonderful article on the logic of suing one's customers. Justin is a really prodigious scholar. He's also someone who's really shaped intellectual property policy. In fact, I think it's fair to say that thanks to Justin, the Clinton administration's intellectual property policy wasn't nearly as bad as it otherwise would have been. Is that a fair comment, Justin? As a longtime consumer of his work, as all of the members of the Duke Law IP faculty are, it is our delight to welcome him here. Justin, thank you very much.
Thank you. It's a great pleasure to be here, and it's a pleasure to be here because it's so beautiful here, and the law school is so tremendous, and of course, Jerry and Jamie and Artie and Jennifer and David are all friends. Jerry Reichman, Professor Reichman, I've known the longest of the faculty here. And as Professor Boyle said, I was in the government for many years, and then we had regime change in Washington, and I was drafted into academia. It's a voluntary draft. I know some of you have professors who you think it must not be a voluntary draft because they don't want to be here, but no. Anyway, it's really great to be in academia, but when I was in government, I met Jerry Reichman. I have to tell you this story. I met Jerry Reichman at a conference we had in 1998, and Jerry got up to speak, and he said, this Justin Hughes, he's this government official you all know who's organizing this stuff, but you need to know he's also the author of a major important scholarly article. And it was a wonderful compliment, and it caused my phone to be tapped for several years thereafter. They eventually decided, nah, he's just talking Hegel and, not page boys and whatnot, so they let it go. All right. First thing, we are talking about geographical indications today. First point, a note of disclosure. I hate PowerPoint. I strongly recommend to anyone who has to suffer through a lot of PowerPoint this small pamphlet by Edward Tufte, who teaches at Yale, called The Cognitive Style of PowerPoint. One problem about PowerPoint is that PowerPoint tends to make presentations that make no sense when you think about it. So instead of putting senseless bullet outline points up on my PowerPoint, I will try to only use it to show you things visually and also to show you specific treaty language. I just wanted to make a, I guess, non-advertisement for the Microsoft Corporation. So I am using PowerPoint, but not willingly. All right. And there's my own advertisement. If this is, this work is coming out this fall in the Hastings Law Journal, and you can get it now just by Googling Justin Hughes Spirited Debate SSRN. Now, what is this debate about? Well, this debate is about geographical indications. Geographical indications are names of places used to designate the geographic source of the place. And we're going to talk about the international law of geographical indications and the debate concerning that international law. But it is a fascinating nexus because in terms of your lecture series, Information Ecology, you have here very blatant issues of monopoly rents for control of words. You have fascinating issues about patrimony. You have interesting issues where intellectual property is coinciding with agricultural policy. So it's a really genuinely interesting area. Now, the prominent or most prominent proponents of geographical indications are the European Union. And not everyone in the European Union takes them seriously, but the people who take geographical indications seriously in the European Union take them very seriously. This is an advertisement from a Madrid newspaper of 2002, and those of you who, everyone can understand what this says, only Parmigiano Reggiano is Parmesan. And you will notice that the judge is pounding on a cheese round, those of you who had not noticed that before. So, very serious stuff advertising that when you're in Spain, don't buy Parmesano cheese unless it's really Parmigiano Reggiano. All right, so what is a geographical indication? Well, the TRIPS agreement is the first time that protection of geographical indications made it into a major multilateral international treaty on a substantial scale. And geographical indications was insisted upon by the European Union as early as 1989, in the beginning of what became the Uruguay Round. And this is the definition of a geographical indication that was agreed upon. The definition is a geographical indication are, for purposes of this agreement, indications which identify a good as originating in the territory of a member, territory of a member or a region or locality in that territory where a given quality, reputation, or other characteristic of the good is essentially attributable to its geographic origin. So those of you who have seen had trademark law, you see that it's a little bit like trademark law. It's an indication, a source indicator, but it's a source indicator for a geographic place, not a source indicator like Coca-Cola or Pepsi-Cola. And what you need to focus on in this language here is that last part, which I had hoped I had a slide where it was bolded. It is to designate goods originating in the territory or region or locality where a given quality, reputation, or other characteristic of the good is essentially attributable to the geographic origin. Essentially attributable. What does that mean? Well, I'm going to argue to you that that treaty language means what we will call a place quality nexus, that there is a unique quality that comes from the good, and its unique quality has its source in the soil, in the land, in the territory. So if you have a geographical indication, what protection are you required to provide at the international level? Well, Article 22.2 of the TRIPS agreement provides the baseline of protection of geographical indications, and as you read that language, you will see that language is not very different than trademark law. It says you must forbid the use of a geographical indication as a designation or presentation of goods in any way that it misleads the public as to the geographic origin of the good. All right, well, none of us are in favor of consumer deception. If the standard is you can't use geographic names in a way that they mislead the public as to the geographic origin of the good, that's fine. No one would want our people to be misled. So in that sense, it looks like a consumer confusion standard from trademark law. And then here, any other use which constitutes an act of unfair competition within the meaning of Article 10 bis of the Paris Convention. Well, we in trademark law in the United States live with some uncertain cases where it seems like what is really being protected are competitors from something we call unfair competition, and maybe not so much consumers. So we could live with that. So at first, it looks like trademark protection. And in fact, there is two competing models of how you protect geographical indications. The model in Europe, or the dominant model in Europe, comes from France. And that is, next time you go to a wine store, you look and you'll find that some wine bottles say they are an appellation d'origine contrôlée, an appellation. There is a specific sui generis system of law that began principally in France and now is in most of the European countries to have a separate labeling, a separate registration system for geographical indications called appellations. Appellations in France or denominazione in Italy. You can correct me, Jerry, your Italian's much better than mine. So one approach is to protect it with a separate sui generis intellectual property system. The other approach is the American approach, and the Americans say, well, no, we don't need that. We can actually have just trademark law. All right, we can protect these geographical indications through certification mark law, or we can protect these geographical indications through collective marks. And the truth is that most countries have a little bit of both. Even the United States, which is a strong advocate that we can protect geographical indications through the trademark law, through certification marks, and through collective marks, we have a special system for wine regions, which we call the American viticultural areas, the AVAs. So even we, when it comes to the specific product of wine, have a kind of geographical indication. Now the problem is when you establish a separate regime for the control of these words, because that's what this is, a regime for control of the use of these words, there may be conflicts between the geographical indications law and the trademark law. And the truth is those conflicts are a totally uncertain mess, even within the European Union right now. So what else do you get beside this? Is there anything else to worry about? Well, here's the American law, which shows where we think a certification mark definition will adequately protect the kind of thing that a geographical indication is supposed to be. So if you look, you see the definition of a geographical indication in the treaty at the top. And you see that our certification mark definition says to certify regional or other origin. So we say, okay, this will serve for a geographical indication. Now, we don't require that nexus between quality and lands. We don't say it has to be a unique quality reputation that is essentially attributable to the geographic origin. We allow a broader range of things to have certification marks. But we say anything that qualifies as a geographical indication can receive certification mark status in the United States. In addition to certification marks, those of you who have had trademark law know that we have another genre of trademark called a collective mark. And we take the position that you could also, as a collective association, register for a collective mark. And that could serve the purpose of protecting a geographical indication. So you have these different possibilities in American law that we say can be used to protect geographical indications. All right, these are some examples of geographical indications that are protected in the United States as certification marks or collective marks, but are protected in the European Union under the sui generis geographical indications law. So this one is familiar to you, Parmigiano Reggiano. You need to know about the thing about Parmesan is that the United States takes the position that Parmigiano Reggiano can be protected as a trademark, but the word Parmesan is a generic description of cheese. This one, Jamaican Blue Mountain Coffee. Another one, Banshu Somen. You wouldn't necessarily think of that as a geographical indication, but it is registered as a certification mark for a kind of noodle coming from the Banshu area of Japan. Darjeeling tea is also a certification mark in the United States. So you see that we have a whole variety of certification marks. There's one finally for a French appellation, Roquefort, and this one again is a certification mark. All right, so if we take the position that you can protect these geographical indications through trademark law, shouldn't there be peace? Shouldn't everyone be happy about this? Well, the TRIPS agreement provides some other things in relationship to geographical indications. One is that there is additional obligations for the protection of wine and spirits. You have to protect more than just against consumer confusion when it comes to wines and spirits. And then there is a bunch of very complex, highly negotiated limitations in the agreement. And then the international agreement does something which very few international agreements do as a treaty. It says we commit ourselves to further negotiations, essentially saying we didn't resolve this completely, so we're going to put off the day of reckoning till later because we really don't agree. So there is a set of substantive obligations, and then there is this treaty obligation, in fact, more than one treaty obligation written into the text of the treaty to continue negotiations on the issue. All right, so what's the additional protection for wines and spirits? This is the additional obligation for wines and spirits geographical indications. Each member shall provide the legal means for interested parties to prevent use of a geographical indication identifying wine for wines not originating in the place indicated by the geographical indication in question, even where the true origin of the good is indicated or the geographical indication is used in translation or accompanied by expressions such as kind, type, style, imitation, or the like. Now notice what is different about this obligation. There is no requirement of deception, no requirement of confusion. It is a categorical control of a word in a product category. If you have control of the word Madeira for fortified wine, then it doesn't matter. No one can say California Madeira or New York State Madeira or Long Island Madeira, because even if consumers aren't confused, you control the word. You also can't say Madeira type, Madeira style. In fact, this is so much broader than consumer confusion, you can't even say imitation. If it says fake cognac, right? How many people think you'd be confused if it says fake cognac? All right, if it says fake cognac, it's still not legal, even though there's no consumer confusion, because the producers in the cognac region, by this treaty provision, control the word cognac. All right, so the treaty provides for wines and also for spirits what I call, how many people have had trademark law or trademarks in IP survey? How many folks? All right, this is a dilution standard, a category-specific dilution standard. You have complete control of the word if you have a wine product in the product category of wines. And this ellipses says the same thing for spirits. If you have a spirit which is named Scotch, then no one else can put something out there that says imitation Scotch, even though no one would be confused. If it is a Scotch-type liquor, you can't even label it Scotch-type liquor. So it's a beyond confusion standard, but only for wines and only for spirits. Now, this was a compromise, because back in the late 1980s and early 1990s, the European Union proposed something much broader. This was their proposal for all geographical indications, whether applying to cheese or sausage or baskets from Botswana or wines and liquors. And if you look at the middle part, the original proposal was that they wanted protection against any usurpation, imitation, or evocation, even when the true origin of the product is indicated or the appellation or designation is used in translation, and then that's the treaty language. But instead of being product specific, it meant if you controlled cognac, you controlled it everywhere. No house paint called cognac, even that's the color. If you control champagne, no Las Vegas dance girl named Champagne, even though there won't be any confusion. So the idea was you have control against any what they call usurpation or imitation or evocation. So obviously this was extremely broad. And the Americans and some people in other New World countries said, no way. And the compromise was, we'll give you this just for wines and just for spirits, and only in the category specific. You'll have absolute control for wine, spirits for spirits, but we won't give you a geographical indication over cognac and then let you prevent Dutch boy paints, also a geographic word, Dutch boy paints from calling a yellow color cognac, because that's outside your product category. All right, so this was the original European proposal, and as you can see, this is where it got limited to. Wines for wines, but still the language at the end, this broad language, no type, kind, imitation, style, or the like, and no translation. So if you have champagne, you have champagne in Spanish or Portuguese. All right, so there are, as I told you, treaty obligations to conduct additional negotiations in this area. And I'm trying to rush through this so we can have a little bit of time for Q&A. But these negotiations have been going on as part of the Doha round because the European Union realizes that they will have to substantially reduce agricultural subsidies in any subsequent agreement for trade, the trade that deals with agriculture. Now, that's a very hard thing to sell to farmers, particularly French farmers in the European Union. And so one thing the European Union is saying is we must have stronger protection of geographical indications. Now, why do they want to do that? They want to do that because if they can control some key words, they think that they can get additional monopoly rents off control of those words to bring back to their agricultural sector. So essentially, the Europeans have sought two things. First of all, they have sought to repropertize many words which we people in the New World think are generic. And these words are, well, we'll talk about those in a second. So they've given out a list, and they've given out a list saying these words, some of you countries are abusing, we want the words back. We want you to agree that there are words. And then the other thing they want to do is they want to strengthen all geographical indication protection so that there's protection against usurpation or imitation of the GI for all GIs, no confusion. So in terms of an information ecology point of view, you think about this. This is an enormous symbol grab, if you will, or a word grab. We want to control these words. So what's this first one, repropertize? Well, it's about champagne, folks. The European Union a few years ago issued a list of 41 words they want back. Now, yeah, they want them back. It's not. I have to tell you a story about this. They want 41 words back, and very quickly, unfortunately, you're a Madison Avenue person, you'd say, oh my God. Very quickly, everybody started calling it the clawback list. Okay, if you're going into negotiations asking for something, you do not want your wish list called the clawback list. Anyway, so it's called the clawback list. It has 41 terms on it, and they want us to return these terms. And of course, champagne drives them bonkers, right? I mean, champagne really drives them bonkers. So here is Brazilian champagne, and here is American champagne. That's not the worst of it. This is Texas champagne hot sauce. This is, I bought this in a sex shop in Greenwich Village. This is champagne bubble bath. They're just furious about this, okay? And the people in the, oh, these are more Brazilians. They abuse the word too, champagne biscuits. And you know, these are very unpleasant negotiations that are going on these issues. I have to tell you a little story. Can I go over a little bit? So anyway, in one of these negotiations, you guys are the only class that's ever heard this. And I was told this by a couple of diplomats. The Argentine ambassador was there with the European. He said, hold on, let me get this straight. You came over to my world. You killed all the indigenous people. You brought over all your people. You named my cities after your cities. And now you want the words back. Okay. So, all right, so it's not just the Americans who are kind of angry about all this. All right, so anyway, the Europeans' position is, well, here's why we want the words back. We want the words back because even though you call that sparkling stuff that you make in Brazil and Argentina and California champagne, it's not really champagne. Because champagne exudes this nexus between the land and the product. There's something special about our champagne that makes it champagne. It's the whole idea that there is some characteristic of the good that is essentially attributable to the origin, all right? And so this is why we deserve to have champagne back. This is why we deserve to have Chablis and Burgundy and Madeira back. This is why we deserve to have Parma ham back. This is why we deserve to have mozzarella back. And I, for many years, thought that this would just be eventually a trade deal. But it's not going to be a trade deal. And that's because we could take care of this if it was about champagne, right? We could cut a deal. But it's really about this word, Parmesan, okay? They want Parmesan back, too. And Kraft has said, over our dead body, you will get this word back. Okay? We sell billions of dollars of this dry, flaky, cheesy tasting stuff. It's called Parmesan, and we get to use the word. So they say, no, it's not Parmesan because it's not, essentially attributable. There's something special about Parmesan. And so let's go on here quickly. Now, here's my argument. There's two reasons why they don't need this additional protection. They don't need this additional protection because the most successful geographical indications that have arisen recently in the past 20 or 30 years from the developing world have done it without the stronger protection the European Union wants. What is the number one successful geographical indication to come out of the developing world in your lifetimes? It's Colombian coffee. And Colombian coffee did that solely under the weaker certification law system of the United States. In fact, because until recently, the European Union wouldn't even let the Colombians or any foreigners register geographical indications in the European Union. So if you go to Starbucks and you see all the regionally labeled coffee, what you see is an amazing story of branding, geographical branding, that is succeeding without legal law and additional legal protections in place. So I see no justification in terms of what's happening empirically for additional protection for these geographical indications. And in fact, the other thing that's happening beside coffee is chocolates. Has anybody noticed that there has been a massive increase in Europe and North America of the regional marketing of chocolates? And if you don't believe me, and now to win you over, I brought samples, okay? And my lovely assistants will break them up and pass them out. And these are Colombian and Venezuelan, and if you will, just kind of break them and pass them back. Geographical indications. And that further protection doesn't seem to be needed for the successful marketing of these products. Now, give me 2 more minutes and we'll go quickly. So, why else do we not want additional legal protection or a heavy form of legal protection for these geographic words? Because you've got to think about the 3 ways geographic words are used on products, our food products. First, it is used to describe the geographic origin of the product. That's unquestionably true. Some of them are. Second, sometimes it's used to describe non-geographic characteristics of the product. That's when you're in North Carolina and you order some French fries. If you have any really slow friends, even they do not think the French fries come from France. And when you go into a Chinese restaurant on the Champs-Élysées, none of the French people are so stupid that they think the food comes from China. So that is a non-geographic use of the word. That is, it's used to describe non-geographic characteristics. And finally, we have to admit that we use lots of these words to create evocative and aesthetic appeal. That's what we use geographical indications for. So let's look quickly at some geographical uses from around the world. This is French bread from Beijing. I'm I think that's just describing a kind of way of baking bread. I think that is a non-geographic description of a word. French bread now. This is Bolognese sauce. This is from Brazil. So the Brazilians, they're New Worlders like us. They're notorious about this. All right, so no one thinks this was brought in from Italy, this Bolognese sauce. This is from Munich. I don't think the Bavarians think this Italian salad dressing is brought over the Alps like Hannibal. Okay, this is from France. This is curry Taj Mahal. Now here we go from a geographical word being used to describe a non-geographic characteristic to an evocative value. Does everyone see? Here, this is an evocative use of a place name, curry Taj Mahal. Doesn't that just make you want to go home and cook it? All right. This is Brazilian chocolate. This is Copenhagen chocolate. Now, we could have consumer surveys that might show some confusion. I'm not denying it's possible, but I just don't think it's there. This is from Cincinnati, Ohio, my hometown, and despite how limited Ohioans sometimes are, particularly in the electoral politics, I don't think any of them think that these potato chips are actually brought in from the UK. Although, this one's a little bothersome because they've gone to the point of even spelling this the English way. So that's a little disturbing. But, Piccadilly, does anyone really think the potato chips come from Piccadilly? No. I think this is a purely evocative use, all right, of a geographic place. All right, so how often do we use these words? Occasionally they can be misused or they can raise questions about legitimate confusion. This is a chocolate bar that is popular in Asia, Ghana. As far as I know, it is not made with Ghanaian cocoa beans. So arguably, this might be a little deceptive, but I think it was, in its origin, purely an evocative use in Asia. This one, again, an evocative use that might be a little deceptive. This is Alpino chocolate from Brazil. This actually is interesting from a legal point of view because in Switzerland, you can't show those mountains unless it really is Swiss chocolate. But in Brazil, you can, and Nestle, a Swiss company, is doing just what they can do in Brazil, not what they can't do in Switzerland. This one, I have to say, is a little deceptive. This is from Paris. This is a chocolate called Les Palais Mexicains. It's deceptive, however, not because it's Mexican palates, but because it says this chocolate can have aphrodisiac effects. Only if that were true, my life would be so much better. All right, so also we have to be careful that the Europeans want to go very broadly with this. They also think that geographical indications includes anything that might connote a geographical place. I mean, they think, for example, that the Golden Gate Bridge would be a geographical indication of California origin. One European scholar has even said the face of Mozart is a geographical indication for Salzburg. All right, so it's a very broad argument area of law. I will close and leave this to you to decide whether you think this is deceptive or not. This is, I think actually I talked to several French officials about this, and this product's no longer on the market, so maybe they had some discussions. This is a brownie made in France. Hello is the name. That's not a French word. Statue of Liberty, skyscrapers. They look a little bit like post-9/11 skyscrapers, but skyscrapers in the background. And this very questionable made in lieu, which looks like made in the US, right? If you're a French person and you don't read English. So, but again, would this be a geographical indication, an indirect geographical indication? Not using a geographic word, but the word brownie. The word brownie is really attached to the United States as a kind of patisserie or a kind of baked product. So anyway, it's a fascinating area where there's this real question about control of words. And I think I should stop there, and we should take some questions. And thank you for enduring with my rambling nature. Oh, one last thing. So what is this? What about evocative uses? I forgot last two I wanted to show you and hand them out. Evocative uses, Milano, Bordeaux. Now, anyone actually think these come from Bordeaux, France? You won't get the cookies by raising your hand. All right, so this is an example of purely evocative uses. And if there was a usurpation standard, no confusion, protection of the word, and it was across product categories to understand the actual practical ramifications, Bordeaux is a protected geographical indication. We recognize it's a protected geographical indication. If that protection were extended, this product would be in dispute, whether or not this product, which has been on the market in the US for 30 or 40 years, could actually still be marketed this way. Same way if Milan or Milano became a geographic indication. All right, I'll hand these out and then entertain questions. Thanks very much. Professor Boyle gets the first question.
Thank you, Justin. That was fabulous. In your paper, you talk about possible justifications, and you're skeptical about all of them, as you were in the talk. And I don't know if this is a justification, but it might be a reason that people are willing to go along with it beyond the kind of naked grab for monopoly rents and a way of having new agricultural subsidies. We see in trademark law the old idea that it was all about allowing producers to invest in the production of goodwill and diminishing consumer confusion has given way to a sort of second generation kind of trademark protection, sort of postmodern trademark protection, particularly after the point of sale, where the courts are quite overt in saying, we know there's no confusion, we know that it's not even a bad product, there's no tarnishment, whatever, but the point is, it matters to people that there only be a very few Ferraris on the road. So we can't even have like shell kits that look like Ferraris out there because they will in some way affect that value. Where the courts are actually saying, we acknowledge that a whole bunch of products exist only to carry their symbol. It's not that the symbol is the mark for the product, ivory, it's you buy the t-shirt because it has the swoosh on it. Okay, so isn't that applying here, that actually the courts are saying, in this kind of economy, in the kind of economy we live, people consume symbols. And it is important that the symbol universe be stable so that I know that my Armani is an Armani, and not just that it is an Armani, but that nothing else devalues that. And similarly, that I can feel superior about the fact that I'm buying real champagne and not just Roederer or whatever.
Right, okay, so it's unquestionably true that we live in an economy of symbols. And it's unquestionably true that there is a hierarchy of utility we derive from these symbols occupying different places. So that when you can afford, a woman can afford a Coach bag, it gives her a little utility that she doesn't get from a cheaper bag. So this is all true. And it's descriptively true. Whether we like it to be true in a normative way is a different question. But it's descriptively true, and it's descriptively true that in trademark law in the United States and also in Europe, courts increasingly protect this value in the symbol regardless of confusion. All right? Now, one of the things that can be said, if you start with that as a starting point in defense of geographical indications, is you can say, all right, you're already living in that world with trademark law. And the nice thing about geographical indications is, unlike the trademark Coach or the trademark Chanel or the trademark Louis Vuitton, this one is attached to the land, and the champagne producers can't get rid of it, and the Pont-l'Evêque producers can't license the Chinese to make Pont-l'Evêque cheese. And so this is good for giving the value, attaching the value to some local people. So that would be a legitimate argument. I'm just very concerned. I'm not so concerned about the dilution protection of genuinely famous geographical indications. I'm very concerned about the clawback list. Because the reason I find the clawback list disconcerting is that there is no calculus of the lost utility. For example, part of what's wrong about the European Union's economic theory is they theorize that if Kraft stopped making Parmesan cheese, all the purchasers of Kraft cheese would purchase Italian Parmesan cheese. Well, the price differential, $18 a pound versus, what? 18 pounds for the dollar. So the price differential tells us that's not going to happen, right? So Kraft is simply going to relabel their thing, as they have done in some countries like Pardano cheese or something. So what will be the result? The result will be a substantial cost to the producer. There'll be a substantial amount of confusion for the consumer initially as the product shifts names. And then also, I want to talk about how much utility is lost by the consumer, because even though this is a low-end product, there's a large slice of the world that feels good about using Parmesan cheese, right? And so if they don't get to call it that anymore, I think that there is lost utility there. So I'm concerned about the clawback list from the lost utility of all the consumers who are used to using generic words which still have a little panache to them. So that's one thing. But no, in terms of answering if we do this kind of strong protection beyond confusion for trademark law, should we do it for geographical indications? It's hard not to say it has to be the same on both sides. So I guess I'm troubled by the strong protection in the trademark side, but I can't stop that. This I can stop. So,
and just one very quick
yeah.
The other, I mean, I think it's terrible on the trademark side too, but the other thing is that the attempt to extend it beyond the product category completely undercuts the argument, right? Because to the extent that what we're trying to do is imagine a world in which we really get $20 of surplus value out of the differential between Veuve Clicquot and Roederer, then if champagne, if we start saying, oh, I can control champagne on everything, it actually has a perverse kind of effect where you're saying it extends far beyond its category.
I think that's true. I think that's true. I think, and that's actually the positive reputational effects of these unpermitted uses or unauthorized uses is also uncalculated. You know, there's a cafe chain in Southern California called Champagne Bakery. Okay, there's no confusion involved here, but I don't think it hurts them, and it probably helps them a little bit. So, yes, sir.
What about the fact that a lot of the value of Parmesan, the word, comes from the fact that Kraft has sold billions of dollars of that stuff? You know, it's not the Italians who created the value in their name.
All right. Well,
the cat's out of the bag already. But
that's a very fair point. But you're actually raising. I didn't mention at all the other huge battleground. Parmesan's one, Champagne's one. The other one involves a little town in Czechoslovakia, and the town in Czechoslovakia makes it's a town called Budvar, and they make. Well, they used to be occupied by the Germans. And when Budvar was occupied by the Germans, they were called Budweis. And so an adjective from Budweis is Budweiser. And so they say that being the town of Budvar, they should control the word Budweiser all over the world. And so there's the huge battle, the most intense litigation battle all over the planet is over Budweiser from St. Louis, Missouri, or Budweiser from Czechoslovakia. And not surprisingly, the German courts have said, it's completely natural that you people, Czechs and Budvar, would want to be called by your adjectival German name. And the Italian courts have said, I really don't get this. You're Czechs who were oppressed for hundreds of years by the Germans. Why on earth would you want to be called by your German adjectival name, except that these guys in St. Louis have made that word famous. The strongest example of where arguably an old world producer is trying to grab back reputational value that was built by a new world producer is not Parmesan, but it's the Budweiser case. And the litigation is all over the park. It really varies country to country. That's probably been litigated now in 25 countries. Yes?
This case has a little touch that you choose not to indicate here.
The Budweiser case.
Yes, the American company is, for the same amount of years, trying to tell the Czech company they cannot use Budweiser anymore. So this really cuts both ways, and so.
Yeah, but again, why does a Czech town want to be called by a German name in Italy? Why does a Czech town want to be called by a German name in Spain? It's a fair question.
Yes,
if it was a Spanish
translation.
translation.
Fair answer to it, because it's also not quite true that only the American company made it famous. There has been a large fame all over Europe for the Czech Budweiser. That
may be. The problem with Budweiser, to complete the story further, is at least in North America, Budweiser probably became a generic term, because there was, in the late 19th century and early 20th century, a whole range of producers of Budweiser in North America. So Budweiser probably was like Pilsner in North America now, understood to be a style of beer. And over time, as McDonald's has done with Mech words, over time, Anheuser-Busch succeeded in buying them out or driving those people out of business. So They reached a point where they were able essentially to propertize a word. It was never litigated. It might have been an interesting trademark case at the time if they were actually trying to make a generic or descriptive, a generic word, not a descriptive word, into a trademark. But it was never litigated. But there's that intermediary story. The reason that intermediary story is important is if it was a generic word, and any place it was a generic word, there'd be a period when the Czechs wouldn't have any rights or the Americans wouldn't have any rights. So it's actually quite complicated. But on this one, I'm actually more sympathetic to Parmesan people and Champagne people because what I'm troubled by is just the idea that if you look into the history of Czechoslovakia and you look into all the anti-German sentiment in Czechoslovakia, it's very hard to figure out why a town would want to be called by its German name in a half a continent in the New World that speaks Spanish.
And so how does quality play into this? I mean, no offenses, but the American Budweiser is really not drinkable.
I make no quality. I make no quality judgments. It's not my place. How many people have taken copyright? Bleistein, Justice Holmes tells us it's not our place to make judgments about art. It is not my place to make judgments about the beer maker's art.
Well, but isn't that what these protections are about too?
No.
Isn't that what the TRIPS agreement told us?
No, that's not. I mean, I'm sorry, we'll have to go on to another question, but no, I'd say just no. There was a hand up here. Yes, ma'am.
Where do you put the line between geographical indication and actually generic words? Like you use brownie, which has no geographical indication, and still you showed it as kind of a geographical indication of the U.S., which is just a generic word, actually.
I consider it a generic word. Let me clarify. My point would be, as far as I'm concerned, brownie is a generic recipe. However, the theory of geographic indications can go to indirect geographical indications. So I will give you an example of that. How many people are familiar with the word claret? C-L-A-R-E-T. Okay, claret is an indirect geographical indication in the European Union. It means red Bordeaux wine. It's not a geographical word at all, but because in the UK, claret was used to describe Bordeaux red wine as being more clear than Burgundy red wine, it came to be a word that is an indirect indication of a geographical place. Well, if that's true for claret, you can make all kinds of arguments, and you could even make the argument about the word brownie. So let me clarify. My personal view is that brownie would not be any candidate at all for a geographical indication, but on a broadly understood indirect geographical indication theory, it could be. Okay? Through the what?
Dilution.
I'm not sure I understand what you mean.
I mean, if people trying to use claret as a non-direct geographical indication, you can say it's confusing for the public when they buy it. So if you try to protect it through dilution, it will be probably easier than through geographical indication.
Well, in the United States, claret would be considered a descriptive phrase for a style of red wine. That's would probably be where it would come out in the United States. And as a descriptive phrase for a style of red wine, no one would have any rights at all. Now, I guess that's the best answer for you. If we determined that it was a geographical indication for Bordeaux red wine, then claret would be protected against any wine use. It would prevent, for example, Francis Ford Coppola's vineyard, the Coppola vineyard, has a claret wine. So if that was a geographical indication, he'd have to give up the word claret, and he couldn't even say claret style wine, and he couldn't say fake claret, imitation claret, claret-like. Okay? All right. Yes, sir. You.
Well, two questions. The first is, I was wondering about what you're talking about with Colombian coffee. It seems as though there's a slight distinction in that it's mostly sort of, the regions that coffee can be grown, America, Europe, these aren't places that are producing it and sort of taking over the market, and so it's sort of different than, for instance, the vineyards where, it's very possible to push out, the little guy or the little vineyards or whatever it is. So I guess I'm curious how you think that just as Colombian coffee was able to succeed without any protection, sort of how the same thing will happen, whether it be with cheeses or some of the other small producers.
Well, I mean, clearly it does happen. The most recent story is there's a story the past 6 months in the New York Times about the amazing success of Rwanda coffee. Now, when I first saw Rwanda coffee marketed in France, I kind of thought this was a sick joke. Because, you know, for a couple of years ago, Rwanda you would not associate with high-quality coffee. You'd associate with human tragedy. So, but they've actually succeeded through quality control and through getting coffee buyers to recognize they have higher quality and then starting out a wave to get a bigger share of the high-end coffee market. So it's a matter of quality control and obviously legal protection. I'm not saying no legal protection. I'm saying legal protection at the standard of a trademark against confusion or deception. So the Rwandans can only build up the value of Rwandan coffee or Ethiopian coffee if they are protected from the Brazilians, you know, marketing their cheaper coffee as real Rwanda coffee. So it's got to be a level of legal protection, just not as high as the EU thinks is needed. Does that's first one?
Yeah, that would be
Okay.
related. So with champagne, for instance, I think, and I understand that a rather large debate, but it certainly seems as though there is confusion. I think plenty of people who are in the store and have no idea that champagne is not, you know, that they're buying an American store. So that there is that sort of deception. But I guess my bigger question is, where do you see the debate going? Given that, I mean, I would certainly think that the California vineyards have generated a lot of revenue because of this confusion. I mean, you know,
Well,
what's this?
Champagne is an extremely interesting word because there's a very good argument that what is happening now is it is shifting from a generic word or a purely descriptive word back to being a geographic origin word. Now, 100 years ago, there is no question in my mind it was a generic word. It was so generic that there's legislation from the late 19th century in California, California state legislation, wine regulations, that established a legal label, California Champagne, right? So in the minds of the California legislature 100 years ago, this was truly a descriptive generic word, so much so that they actually codified it into regulations into how wine would be labeled. Since then, there's been a movement, particularly as you know, our bobo and our upper middle class has developed more expensive tastes. There's been an increasing movement away from champagne being used for non-French wines. And the situation now is that most high-end producers in the United States of sparkling wine have abandoned champagne. And the only people who are still using champagne are really low-end producers like Corbel. So, you know, next time some of your friends bring New York State champagne to a party, you'll know, not a high investment. So it's a word that's shifting, but it's hardly shifted yet. I still think what is really amazing is, you know, when you think about I want you to, for the next few years, in the high-end circumstances in which you live, the highly educated, high-end economic elite of this country, how often you will hear somebody say, have a glass of champagne, and you will know it's California sparkling wine, or you will know it is Australian sparkling wine, and they'll just say, have a glass of champagne. So now we're at a point where official documents are changing, and labels are changing, and maybe, you know, and there's no mistake ever made in Wine Magazine, or Wine Spectator Magazine, or Saveur Magazine, but people still use champagne generically when they talk. So it's a very interesting gray period we're in. That's actually what I've done a fair amount of research on this. David?
Justin, could I get you to opine on something? I'm interested in the idea of not being able to use labels that say reminiscent of or like or things of that. Let me give you this hypothetical. I'm Kraft and I've been done out of my use of Parmesan. So I begin to market everywhere, including in the United States, by calling him Pardano. I mean, I don't think that Kraft will give up that easily. Let's suppose they do. May I then say, in a prominent way on the side of the package, that this cheese product resembles Parmesan cheese, Parmigiano Reggiano cheese, which we formerly sold as Parmesan cheese, but which we are now obliged by virtue of our treaty relations not to continue to. I mean, you can see where this is.
He's asking about truth. You know, is truth a defense to a treaty violation?
That's precisely it.
Yeah. Okay. So this is a very, and I didn't, because of the limited time, I really didn't get to focus on this point enough. what is wonderfully interesting about the idea of if you bar uses of using imitation Parmesan, Parmesan-like, Parmesan substitute, Parmesan, fake Parmesan, is think about how much consumer utility you are eliminating. It's extremely efficient to say Parmesan-like cheese, right? Or substitute Parmesan, right? These are very efficient ways for us to communicate product characteristics. And so when you put the legal protection so broadly that it eliminates to all that, you really are eliminating a lot of communication efficiency between producers and consumers, which is a very valid concern. Now, the question is, what happens about back labeling? How far can you go in truth say, this really tastes like Parmesan Reggiano? And the interesting thing, and that goes, David's raised another interesting point, is so this ban against cognac-like, substitute cognac, fake cognac, obviously at some point it's going to, bam, collide with American law on comparative advertising. Because we believe that you can engage in comparative advertising. We believe you can say, compare our fortified wine to cognac. You'll never turn back. I just made that up. So, all right. So at some point when you say not cognac-like, you can't say imitation cognac, and you say, okay, wait, I believe in comparative advertising. Can I say compare me to cognac? Taste me, and I'm better than your cognac? So it's got a real issue about comparative advertising and most of you should know the European Union, most European Union jurisdictions do not have strong protection of comparative advertising like we do. In Germany, comparative advertising is virtually taboo. At least that's my impression of the legal status in Germany. So they say that's no problem. You don't need to compare your wine to cognac. You don't need to. Yeah.
Sort of related to what David said, it strikes me that there's an underlying idea of language and how you can control it. And I guess I was struck most when you're talking about champagne, because the French have laws and various ways they try to control what is official language and how it can be used, whereas I guess English is known for sort of mutating all the time. And when I think of the number of ways the word champagne is used, stay at our hotel, it's the champagne experience. I mean, it's
right.
The idea that you could ever rein that in strikes me, with my American sensibilities, as ludicrous.
I think that's an excellent point, and it is true that France in particular, certainly not true of the UK or the Nordic countries, but France in particular lives in a culture where there is more formal regulation and accepted regulation, both as a matter of law and as a matter of social norms of the language. And you can connect this, I think that's a lovely point, you can connect this to, they have an Académie Française, which says what is good language and what is not. And we laugh at that, right? But if you live in a culture that has an Académie Française that tells you what are real French words and what are not, it's just a small leap to get to a regulatory structure which says you can't use the word chateau on a bottle of wine unless it's French. Because, yeah, we're out of time.
At this point, so I think a huge round of applause for Professor Hughes.
Thank you very much.